my writing of the executive power essay that I gave you. I've decided to do a bit more planning on this essay, as you can see right here, than I usually do when I try to live write or try to write essays and record myself writing essays. I try to do it authentically. I try to do it for the first time to really kind of show you sort of the mental processes and sort of ways in which I approach aspects of the writing process in a very original way. But I think this time it needed more planning because I plan on integrating all of the evidence because I'm also using this essay writing recording as a way to review some of the essential material that you need to know. So my essay is going to be a bit more complicated than yours, but don't worry. That is only due to the fact I'm also using this as sort of a forum to talk about and review content. So in the executive power track, you can see right here, it says develop an argument that explains whether or not a strong executive is best to ensure the long-term survival of a Republican form of government. In your essay, you must articulate a defensible claim or thesis that responds to the prompt and establishes a line of reasoning. Support your claim with at least 2 pieces of evidence and accurate and relevant information. So here are sort of like the notes that I jotted down from class. Or actually, it might be best if I just left these up there so they can sort of prompt me one way or the other. But obviously, these will be blank. It might be helpful for you to do sort of a brain dump as you encounter the evidence, so you just don't forget what is actually contained in maybe a foundational document, or what are the key implications or restrictions, or what's the context behind a major piece of legislation, so on and so forth. But definitely after you read the essay, you want to have a thesis statement in mind, right? My thesis statement, I actually didn't plan this out. I just kind of have a list of some of the several different elements that I want to talk about, and then I have links saved in to sort of allow me to talk about them as quickly as possible. So let's go ahead and go through this. So the first piece of evidence that you see is Federalist 70, right? And so we've encountered Federalist 70 before quite a bit in this class. And the Federalist Papers, it was written by Hamilton, and it was arguing for an energetic executive, right? There was a debate about whether the executive branch should consist of whether the power of the executive branch should be vested in a single person, or whether there should be some sort of council, a deliberative council that comprise the executive branch. And Hamilton seems to come across heavy in this idea that the executive branch should definitely not be one that is unnecessarily constrained, that you want an executive branch that is going to be able to execute the laws passed by Congress with speed. There's some famous quotes here in Federalist 70. You can see I use the Avalon Project. There can be no heed, however, to multiply arguments or examples on this heat. A feeble executive implies a feeble execution of government. A feeble execution is but another phrase for a bad execution, and a government ill executed, whatever it may be in theory, must be in practice a bad government. Yeah, so it says, yeah, so it talks about sort of the trade-offs, and then it even says like decision, activity, secrecy, and dispatch will generally characterize the proceedings of one man in a much more eminent degree than the proceedings of any greater number, and in proportion as the numbers increase, these qualities will be diminished, right? So these, sort of saying that a larger body would be probably more deliberative, less prone to engage in secrecy, but also be something that is a branch characterized or a body where decisions diminish, right? There's the space between them become larger and larger as you increase sort of the body charged out with the task, which is interesting, right? Hamilton has a sophisticated understanding, and he's a very intelligent man, a sophisticated understanding of sort of the trade-offs inherent to a council of executives potentially, or a vesting of the executive power in a single executive, a single person, the President of the United States. And so, obviously, sorry, I guess I was choking on my spit. Obviously, you know, Hamilton's argument can be applied to the present context, right? And that's what we try to do in government. We try to take elements and pieces of arguments, or try to understand sort of elements of the Constitution and like how it's evolved over time, and maybe take, you know, arguments and sort of events that have happened in different contexts and try to apply them, you know, most interestingly to the present day, or of course maybe other eras in American history, right? So Hamilton's argument is obviously an enduring argument. We can kind of see it in the sense that the presidency seems to definitely be an institution that is more prone to fast decision making compared to the more, one would hope, deliberative Congress, which is less prone to fast decision making. Of course, with 538 members in Congress, you have sort of a collective action problem. You know, things move a bit slower in the legislative branch. And that seems to be a sort of structural design, right? And when we get into the war powers part, I'll argue that the founders intentionally gave the power to declare war to Congress because they wanted to sort of you know, give it to the more deliberative body, right? The body that was designed to be more deliberative, and to sort of put the brakes on making sort of big, bold decisions, right? The executive branch, however, as Hamilton argues, needs to execute the laws. They need strength to get stuff done and to act with force and speed. Okay, so that's obviously an interesting argument. Strong executive equals good government, right? I'm just abbreviating here, but I would probably want a little bit more description and elaboration of what's actually in Federalist Number 70. Obviously, you're paraphrasing these documents in these pieces of evidence because there is quite difficult language in a lot of these documents and pieces of evidence, and you would never actually be required to commit those to memory. And so the second part, the Declaration of Independence, we can talk about like predictably the commitment to inalienable rights, but I would also argue that we could talk about the list of grievances in the Declaration of Independence and this deep suspicion of the king. It lists explicit grievances of what it terms our tyrannical disposition of King George III, of like sort of the tyranny, I would say. I think tyrannical disposition is too verbose, but what it calls the tyranny of King George III. And then finally, we can see other, we can sort of apply the Declaration of Independence. It's kind of like a weird piece of evidence that I feel like you can apply in this essay, but you certainly could apply it in this essay. You could sort of talk about how the Declaration of Independence had a deep suspicion of the powers vested in, or a deep suspicion of tyranny, which is associated sort of with you know, allowing too much power to accrue in one person. And so we can sort of see and apply that in a different way to sort of this argument that we're going to build about whether we like a strong or a weak executive. And then we can also see here, I'm going to erase this here, the Constitution. There are so many different elements of the Constitution that you can actually cite, right? Yeah. And so we might actually want to look at, so every time they give you the Constitution as a piece of evidence, I want you to go and try to find a specific piece or cite a specific article, cite a specific clause. In particular, I'm going to go to Article 1 and Article 2. Article 1 enumerates the powers that Congress has. Article 2 delegates or talks about the formal powers of the presidency. And then Article 3, of course, is the sets up the judicial branch of government. But the reason why I'm going to go to Article 2 is because we know from Federalist 51, remember Federalist 51, which is also another one of your pieces of evidence that you can choose for, which talks about the importance of checks and balances and separation of powers in our government, which sort of doesn't clearly delineate spheres of power, right? Kind of has overlapping circles or domains in which the branches of governments are supposed to exercise their authority, because it wants that tension between those branches, right? Because our government was specifically designed for ambition to counteract ambition. Remember, the language of Federalist 51 says that men are these terrible creatures. They're not angels. And so we need a system where there's constant tension. There's gridlock at times too. There's this ambition made to counteract ambition, right? So I'm going to look to Article 1 with this knowledge that maybe there are some powers delegated to Congress or enumerated in the Constitution that Congress possesses that sort of, ooh, my music cut off. Sorry, I'm trying to play music to help me rush through this. Oh my goodness. Maybe there are some powers that are enumerated to Congress that is in tension with or necessitates action by the executive branch or some sense that can perhaps, be a part or element of our essay. And specifically, if I go back, I see that one other bit of evidence that I could use is the War Powers Resolution. And I know, right, because Mr. Diaz has talked so much about like the fact that his students are younger than the war in Afghanistan, which apparently is going to, according to President Biden, he has committed to withdrawing U.S. forces on a non-conditional basis from Afghanistan before the September 11th anniversary of this year, right? So that will be interesting, right? That war is older than you. And right, we've talked about these wars and we've talked about the conduct of these wars, and in particular, the way and treatment of detainees in these wars, sort of the interesting moral and legal questions that came up with it. And we kind of saw, or several of you sort of identified what seemed to be the executive power having all this authority in the conduct of war, and having this ability or seeming unchecked in their exercise of various authorities and committing United States forces to engage in different parts of the world in the name of the global war on terror, right? Or perhaps, as the Obama administration would say, the global war on terror is the phrase in the Bush administration, but the Obama administration might say something else, like countering terrorism or something. And so we can go to Section 8, which enumerates all the powers of Congress. Enumerates means numbers, right? Let's see. Section 8 of the Article 1, Clause 3, to declare war. So Congress shall have the power to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Right. So this war declaration power is hugely significant. And so, like I said earlier, the founders certainly seems like they intended to grant Congress the power to take the country from peace to full-blown war, but it raises interesting questions, such as, can the President of the United States use any forces unilaterally? Because the President of the United States, as we'll find out in Article 2, is the commander-in-chief of the armed forces, right? So there's this sort of shared power that is alluded to in the Constitution, this shared domain of powers that Congress and the President has, it seems, when it comes to war, right? It raises interesting questions. I already said, could the President of the United States use any force unilaterally, meaning on his own, if it was short of a full-blown war? Could the president authorize something short of invasion? Does the president have authority if there's an imminent national security threat to commit the United States to counter that threat? Sort of where is this line drawn, right? The president is commander in chief of the armed forces. What is the meaning of that? That means the president has, has to have some discretionary authority over how war is conducted. But does that mean the president can deploy troops in such a way in the hopes that perhaps maybe hostilities will be initiated, right? And sort of something short of a full-blown war declaration, right? And we've the war in Afghanistan, for example, is not a declared war. The war in Iraq is not a declared war. The last declared war was World War II, right? So we can kind of see perhaps a ceding of power, and we'll talk about maybe the political incentives that exist for Congress to maybe cede war conducting powers to the executive more and more, right, to avoid the political costs associated with perhaps a war that is dragging on too long or not producing enough results, to kind of buck the political responsibility associated with it. But it certainly seems to be an interesting area, right? So I could talk about Article 1 powers. I could talk about a range of Article 2 powers, which seems most relevant considering we're talking about the executive branch. Right? So I can talk the formal Article 2 powers, and I have to make this distinction between formal and informal powers. So what we mean by formal powers, we mean that they're when we're talking about the presidency, we mean that they're expressly written, or they're powers that are, in Article 2, right? They're evidence you can put your finger on it, right? They're formal powers. Now, some people oftentimes make a distinction where they group implied powers with formal powers, and then they talk about informal powers like the president being like the center of attention, or having like sort of this bully pulpit, having this role as chief legislator or leader of his political party, or their political party, I should say, right? Hashtag, let's get, let's make progress, America. But for our sake, we're just going to say that formal powers are stuff that we can put our finger on in Article 2 of the Constitution, and they include stuff like, let's see, the executive power. The vesting clause is super important. The executive power shall be vested in the President of the United States of America. This is a significant clause, right? It's significant because the presidency oversees, especially today, a enormous bureaucracy. Right, so this suggests that enormous bureaucratic institution has to have some form of deference to the presidency, right? And we've talked about these extreme views, right? Because there are different types of views and perspectives about the extent of presidential power in American history. But these extreme views that especially we looked at with the Bush administration called the Unitary executive views, this idea that the executive should be is unitary, right? That the bureaucratic institutions or bureaucrats cannot be held accountable in an election, only the president can. And so therefore it makes the most logical, it makes sense that the bureaucratic agency should be an extension of the president's will, right? They should be a direct extension of the president's will, because the president is the one that is elected by the American people, not the bureaucrats, right? It's probably a non-charitable summation of the unitary executive theory, but oh well, we're short on time. But this vesting of power, of executive power in the presidency of the United States, has also have significance. It takes on added significance because there are some that say this vesting of executive power suggests that there are more inherent powers to the presidency than are specifically spelled out here. They cite, that other countries' executives at this time period had a wider array of different types of powers, but we're not going to get into that technicality right now. And then it says right here, here's in section 2, the president shall be commander-in-chief of the Army and the Navy of the United States, right? Suggesting that the president has some sort of discretionary authority over the way in which the armed forces of the United States can engage in hostilities. If not war declaration, then perhaps something shy of, full-blown war, maybe engaging in minor hostilities or skirmishes. Does the, interesting questions of whether that arise from the founding and get answered with judicial precedent and of course historical precedent and so on and so forth, or don't necessarily get answered but get more complicated, I should say. But over what or what authority does the president actually have in terms of committing American armed forces to engage in hostilities? Can Congress, we're not going to go there. And the militia of several states, when called into actual service in the United States, he may be require the opinion in writing of the principal officer. Okay, he shall have the power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate and by with and the advice and consent of the Senate shall appoint ambassadors, other public ministers, and counsels, judges of the Supreme Court, and all officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, and the president alone, and the courts of law or the heads of department. Okay, let's. So we can see here this, again, these checks and balances, Federalist 51, right? The president has the ability to negotiate treaties, provided that the treaty is consented to by 2/3 of senators, then the treaty can become ratified. But the president definitely has this role as chief diplomat and can nominate ambassadors. And then, of course, the cabinet that the president compiles of different agencies like the Department of Homeland Security, or maybe independent agencies like the Central Intelligence Agency. The president has historically nominated heads to those departments, and the Senate has to confirm those heads, right? The Department of Justice, so on and so forth. And then the president shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commissions, which shall expire at the end of their next session. Okay. And finally, Section 3, president shall communicate to Congress. He may convene and adjourn Congress in case of disagreement, etc. Where is the pardon power? Sorry. So we see that the president has his formal powers include he can appoint officials like ambassadors, treaties, and we see the tension between or the intentional overlapping sort of authority between Congress and the presidency. And it requires 2/3 of the Senate to confirm or to ratify treaties, 2/3 to appoint official ambassadors. And then this has been extended to like cabinet secretaries. Let's see, where's the pardon power? Oh, here. And he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. So that's the pardon power. So what's interesting about pardons, right? So the idea behind pardons, which are essentially the ability for the president to forgive crimes, and this pardon power has also encompasses commutations, the ability of the president to eliminate or reduce sentences. Is this idea to it was spelled out in Federalist Number 74, kind of lessen the blow of like maybe harsh justice. Like several of you conveyed dismay at sort of the harsh sentences for drug abuse, or maybe there's someone that we think that the justice system, for whatever reason, did them wrong. Now there's like a formal pardon process, and we'll talk about how the norms that have developed have sort of been obviated, especially in the Trump administration, but we kind of saw that to some extent at the end of the Clinton administration as well. I should also note, like, obviously norms develop, right? These ideas, the socially sanctioned ideas about acceptable behavior develops over time in our system, right? There is a formal process to apply for a pardon. Now, obviously, that process is not spelled out in the Constitution, but over time, that sort of thing develops. But we could talk about conceivably all of these things, right? I'm going to talk about the commander-in-chief power. I'm going to also try to talk about pardons. We can also talk about the fact that treaties are much, much more difficult now. When we think about like the Paris Climate Accord, for instance, negotiated under the Obama administration, the Senate was not going to ratify that treaty, which aimed to reduce greenhouse gas emissions, because it needed 2/3 of the Senate, and Obama, obviously, I think the Senate was controlled by Republicans, and for whatever reason, they had objections to the Paris Climate Accord. I don't recall their specific objections to the Paris Climate Accord, but I'm sure you can look it up. So Obama negotiated what was called an executive agreement, which is essentially sort of embodying the president's role as chief diplomat. The president can commit to an international agreement. Of course, this commitment to this international agreement has, significance, but the next administration can withdraw, or could rescind the agreement, right? It's executive agreements are sort of ways to get around the increasingly gridlocked politics that we have in Washington, D.C., where our institutions seem to produce, not where our institutions seem to, but sort of like we'll talk about this trend where there's increasing tools that the presidents have now come to use that really kind of originates as the national state and the national bureaucracy gets bigger and bigger, such as a range of executive actions like executive orders and executive agreements that kind of circumvents or obviates the need to go to the Senate for or go to Congress for help, right? You can sort of advance your policy agenda without needing Congress. Of course, you would prefer Congress, right? And we'll talk about it. Why? What are the limitations of sort of executive orders and executive action and stuff like that? With executive agreements specifically, obviously, Obama entered us into the Paris Climate Accord, and Trump took us out of the Paris Climate Accord, and now Biden is submitting that he wants to bring us back into the Paris Climate Accord. So the same with executive action, executive orders, which I'll talk about in a bit. They can be rescinded or modified depending on who's president in the United States. Okay, so I talked about pardon power, though. And so I wanted to also just show you, right, so access, influence, and pardons. So in the Trump administration specifically, there was a lot of criticism about sort of the pardons that President Trump granted. And so I'm going to include this article in the description of this YouTube video just for your reading. So you can kind of also see that the way in which our system sort of develops, right? There's this interesting book called After Trump by Bob Lauer, and I forgot the other professor's name, but there are two professors at Harvard Law, one that served in the Bush administration, one that served in the Obama administration, that sort of say that the ways in which President Trump has sort of, become a norm entrepreneur is that he doesn't really do things that are necessarily violative, or the areas in which he has profoundly changed the president are areas in which there are long-held norms, but not exactly laws, right? He's a habitual norm violator, as they term him. And so it was obviously a very critical book of Donald Trump, but it also talks and chronicles this increasing accretion, it seems, of increasing power in the executive due to different political dynamics that exist, right? We talked about increasingly, it's hard to get stuff done with Congress because even if you have a unified government, as we do now, that's an instance in which the same party controls both Congress and the presidency, that coalition may have different ideological composition throughout that coalition. So we can have like very conservative Democrats like Joe Manchin in a 50-vote Senate, and all it takes is one to break, and you can't get, it seems, anything done. So, dang, there's so much to talk about. I really just shut up. But this is an interesting article that talks about how there's this sort of trend at the end of the Trump administration, or the trend in the Trump administration, to grant pardons and clemencies to individuals that are well connected to the president and are potentially can damage the president politically or even implicate him in potentially like a variety of legally problematic matters. So I would also just note, right, to keep this bipartisan, the spirit of bipartisanship. So this also talks about Pardongate 2.0, sort of the long list of pardons that President Trump granted before he left office. But Pardongate 1.0, this talks about like President Trump's long list of pardons, 140 in total that he granted before he left office. And there was obvious, at least it didn't sit well with a lot of people. Both instances did not sit well with a lot of people. So I'll include these links in the description for your own viewing. But there's sort of this personalization of these powers that are granted in the Constitution that might have, sort of benign intentions, right? It might be beneficial for the president to have this ability to pardon or commute sentences, right? In this idea that, justice can be a little harsh sometimes, right? And so maybe somebody just really needs a break. But obviously, it seems like this power can be pretty expansive, and it is considered one of the most expansive powers that the president has, and therefore can be, as several critics have alleged, prone to misuse. Okay. And then, so those are the elements of the Constitution, right? From all of that, like that was just one piece of evidence, right? But I can take any of those different elements to create a really effective essay. In fact, that's probably why this essay is so hard for me to write, because there's so many ways in which I can write it, right? So I talked about treaties, pardon power, commander-in-chief. I could also talk about implied powers that derives allegedly from these formal powers that presidents have historically claimed. And so one is interesting is executive privilege. So I can include this lawfare article in the description. Executive privilege is the proposition that certain confidential or sensitive communications within the executive branch are constitutionally protected from compelled disclosure to its co-equal branches. So obviously Congress has the power to investigate and initiate investigations. They have subpoena power, but executive privilege has long been sort of claimed by the presidency and the executive branch to sort of push back against, the acquisition of materials that can potentially be sort of damaging to the president, or as is claimed often by the executive, to national security, or damaging to the Republic in maybe different ways, right? And so you can think about, plausibly, we would want the president's communications to be somewhat protected, to be somewhat unreachable in some contexts from the courts or from Congress. I mean, what if there are, important national security matters? Obviously, the president has a vast bureaucracy, and he has, or he, I guess, right? He has easy access to, the national security bureaucracy that exists, like CIA intelligence, NSA intelligence, and stuff like that. And so, although we have like House committees that now oversee those intelligence agencies, these vast intelligence bureaucracies. The president is still obviously receiving very delicate communications, and potentially we don't want all of those communications to be unprotected. But we also want the president to be advised candidly, right? And we don't want people to not advise the president in a non-frank matter or a non-candid matter because they fear that their communications will potentially end up in a congressional hearing that is aiming to slander them to kind of end their political career or to kind of go after the president, right? So it's reasonable to think that the president, the vesting clause comes with executive privilege, right? This has been long claimed by presidents. The Supreme Court finally gets a say in it in 1974. So in 1974, this is an interesting case in the United States versus Nixon, where the Supreme Court recognized a constitutionally based privilege protecting the confidentiality of conversations between the president and his close advisors, but they say it's not absolute, right? They still force Nixon to turn over important documents to a grand jury that has subpoenaed those documents in a criminal investigation, right? But that's a whole nother rabbit hole. And so what is the scope of executive privilege? Well, the branches of government are at odds, right? Which makes our system so interesting, and which makes being a lawyer so interesting is because there can be so many different answers to questions. But obviously presidents want a more expansive view of executive privilege. They even want maybe the deliberative process that doesn't even involve them within an agency like the ATF or, for instance, in this particular example, they talk about the Fast and Furious scandal in the Obama administration to be sort of protected, right? And immune from sort of congressional harassment, the thought is. But we're not going to get into this, but this is one example of implied powers. I'll include this in the description. And then we talked about executive action a little bit, but I want to go back and talk about executive action more extensively. And so specifically, I want to talk about executive action and executive orders. Those are, again, another implied power. You can't necessarily find them in the Constitution, but because you have the Constitution as a piece of evidence you could use, you could definitely talk about the president's veto power, the president's ability to appoint officials, the president's treaty-making power, which has restrictions upon it, right? It requires 2/3 approval by the Senate, but then the president has historically been able to get around that with the initiation of the executive agreement. You could talk about how the pardon power has become, it seems, increasingly personalized or can be prone to abuse by presidents. You can talk about the commander-in-chief role and sort of the interesting questions that it raises, and we'll get more into that when we get into war powers. You can talk about executive privilege, and you can also talk about executive action, agreements, and orders. So what are executive orders and actions? Well, the definition of executive orders is that it is, well, let me find you an interesting definition. Philip Cooper's definition: directives issued by the president to offices of the executive branch requiring them to take action, stop a certain type of activity, alter policy, change management practices, or accept a delegation of authority under which they will be responsible for the implementation of law, right? So this executive orders really become significant with the expansion of the federal state, which we see most dramatically in the 1930s. Well, currently, the federal government's budget is $4.2 trillion. The vast majority of that budget is in the executive branch, right? The executive branch oversees all these programs. They're executing the laws that the legislative branch is putting forward. So the president is in charge of that vast bureaucracy, right? So executive orders can have a lot of significance. And we discussed this before when we talked about regulatory agencies, which you need to go back and look at. But we said that Congress oftentimes passes statutes and acts, but they're not necessarily technical experts in every aspect of the law. And sometimes they leave a lot of ambiguity in laws, either intentionally or the language of the laws are, just naturally ambiguous. And so it leaves room for the president to sort of, through executive action, interpret, perhaps even very broadly, their delegated statutory authority. Statutes are laws passed by Congress in perhaps very broad ways or maybe restrictive ways. So I'll give you an example in a bit. Or it perhaps executive orders become a mechanism that the POTUS can use to assert their constitutional powers that they believe that they possess, and they are binding, right? Since the executive power is vested in the President of the United States, of course, there is some independence within these many different agencies. There might be some norms of independence within these agencies themselves, right? The Justice Department, we're hearing about the importance of the Justice Department being independent from the president, right? This probably stems from a norm, right? The Justice Department was created significantly after the founding of the United States. This stems from a norm that takes place over time, a social norm that develops, not anything that's hard constitutional law, and certainly stuff that has been violated actually very recently. In the Trump administration. No evidence in the Biden administration yet. But increased partisan polarization. What was I going to talk about? Right. So executive orders are meant to affect like the vast the bureaucrats, right? The behavior of bureaucrats in the executive departments and agencies. But naturally, because the federal government is so big, it has effect on private actors as well, right? And there's so much that the federal government oversees now. There's so much that they regulate that and obviously laws are naturally ambiguous, and sometimes there are some agencies that have quasi-legislative functions, as we talked about before, like the Securities and Exchange Commission, so on and so forth, because Congress kind of passes the legislative buck because they're not technical experts in everything, right? The executive orders have become a way, especially in an era of increasingly partisan politics, for the president to enact their agenda, right, without the help of Congress, right? So I'm going to include some examples. And so some interesting examples of this would be sort of, not this actually, that's not what I wanted. Did I not do Obama? I thought I did. Oh yeah, so no, that is the same one. Okay, so Obama administration, for instance, the Obama administration's Environmental Protection Agency, obviously they couldn't get a law passed through Congress to tackle climate change, and so they proposed a new series of regulations called the Clean Power Plan that were more restrictive, more hardline approaches to addressing and attempts to reduce greenhouse gas emissions and to force states to reduce greenhouse gas emissions. It was promulgated in part through to a very broad reading of Obama's the statutory authority that the the executive branch had under the Clean Air Act, right? The Clean Air Act, the Obama administration claimed it gave them power to enact the Clean Power Plan. The Clean Air Act is a 1970s law, right? And the Obama administration claimed that it gave them power to enact the Clean Power Plan, which had intense regulations. But nonetheless, it was a very broad interpretation. But we also have this other branch of government that can check this branch of government, and it's the Supreme Court. And so actually the Supreme Court ruled in 2015 or 2016, I believe, that the Obama administration had to, after it was being sued by 28 states that thought that the regulations were too onerous, and obviously various interest groups that were fighting against the regulations, the Supreme Court forced the Obama administration to delay implementation of the Clean Power Plan because the Supreme Court has this power of judicial review, the ability to render an executive or legislative action unlawful. But then the case is effectively moot because Trump gets elected and he rescinds the Clean Power Plan and he replaces it with his own rule called the Affordable Clean, I don't know what it's called. You can read this, right? This is not, you don't have to, right? You don't have to know the details. This is just a case study too. I don't know what it's called. The Affordable Clean Energy. Yeah, Affordable Clean Energy. Scott Pruitt was the director of the EPA. They rescind it with a less onerous regulatory scheme, critics allege, because they were perhaps had a less hardline approach to tackling climate change in the Obama administration. And one of the interesting thing about this too, right, it shows like how these presidents have essentially through executive action have enacted, different policy agendas, but are also constrained in some sense too, because the Trump administration couldn't actually not enforce the Clean Air Act. There was a Supreme Court ruling in 2009 that made clear that you had to, it says right here, Massachusetts versus EPA, that the agency has to limit greenhouse gases under the Clean Air Act if they're a threat to public health. And so they had to replace Obama's CPP with another plan to regulate greenhouse gases. So they couldn't just not regulate greenhouse gases, which is very interesting, right? It's an interesting bit and shows the ways in which our system still has constraints and executive orders and executive actions can still be constrained. Okay, so that's interesting. And then finally, okay, so all of those things we've talked about, those are elements of the Constitution, right? We can go sort of down a rabbit's hole with the Constitution. And then Federalist Number 10, we've talked about Federalist Number 10, and we usually pair it with Brutus Number 1, which has the suspicion. Brutus Number 1 is that anti-federalist document that has this strong suspicion of putting increasing power into the national government, that wants more powers reserved for state governments. And Federalist Number 10 argues for more power in a national government. They say that a larger republic is actually best because it forces competing interest groups and competing factions to compete over a larger republic, so they can't actually gain as much power as if they were competing in a smaller republic. Right, and so we can actually play, this is a side note, Federalist Number 10 and Brutus Number 1 arguments as sort of, I think they can contribute to the Reconstruction debate and may be used as evidence. So think about that in your civil rights essay. And then finally, Federalist Number 51, which I talked about, ambition must be made to counteract ambition. The Articles of Confederation, it was incredibly weak, heavy on states' rights, Shays' Rebellion, weak government, bad, 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 bad. So maybe we can use this if we want to argue in favor of a strong executive. And then finally, the War Powers Resolution. This is an interesting bit, because war powers, as I talked about a little bit earlier, have seemed to skewed in favor of the President of the United States. We talked about the wars in Afghanistan and Iraq a little bit in this video. We've talked about them extensively. And although Congress authorized both wars, right, they gave an authorization to use military force, they did not actually declare war on Afghanistan or Iraq. But you can see right here the authorization to use military force that Congress submitted in 2001, whereas in September 2, the acts of treacherous violence, and Congress says the president has authority under the Constitution to take action to deter and prevent acts of international terrorism against the United States. Now, for be it. The president is authorized to use all necessary and appropriate force against those nations, organizations, or processes who determines plans, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or person in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. Guys, this act, this authorization to use military force is still in place, or it's still become like the legal justification that subsequent administrations, the Obama, the Bush and the Trump administration have used for engaging in hostilities and committing armed forces in hostilities, not only in Afghanistan, but throughout the world. I'm talking about Somalia. I'm talking about Yemen, all over the world, right? And you can see that this authorization stems from War Powers Resolution's requirements. Specifically, the executive branch has pushed back on the War Powers Resolution. So what is the War Powers Resolution? Well, it is a resolution that was passed after the Vietnam War, after people became very suspicious of the powers of the executive branch, specifically of the president himself. There was a sense that there was an imperial presidency, that the president was accruing increasing powers, and then it took place after a very unpopular war and after years of Congress sort of abdicating the responsibility of going to war to the president, or sort of just walking over for the president if the president wanted to engage in conflict, or not putting enough of a fight, I should say, right? Kind of just rallying behind the flag, so to speak. Maybe that's a bit unfair. I'm sure there's a more complicated history there. But essentially what the War Powers does, it's passed in 1973, it requires 48-hour notification of Congress before U.S. armed forces are introduced into hostilities or imminent hostilities. And it says that any action that is taken, like there's a 60-day time limit for which U.S. armed forces can be committed to hostilities without congressional authorization. And presumably after that time limit expires, those troops need to come home, right? Of course, the UMPs suggest like this War Powers Resolution is, sort of, or not the UMPs suggest anything, they don't. But the War Powers Resolution is interesting. It's very vague, and it hasn't been vigorously enforced by Congress, only because Congress is sort of incentivized to kind of buck the responsibility of war execution to the president, and not necessarily oversee as vigorously the president's conduct of war. As congressional leaders don't want necessarily political responsibility and culpability if war goes badly, if there's some type of foreign policy crisis. And it has traditionally been seen as the domain in which the president has gained increasing influence and power, right? The authorizations to use military force are War Powers resolutions that are super, super significant, but nonetheless are wait, where was I going with there? But the presidents have kind of like stomped all over the War Powers resolutions with sort of impunity. So there's this great example from the Obama administration where Obama actually commits the United States to support Libyan rebels. U.S. Air Force plays a significant role in supporting Libyan rebels in 2011 that are attempting to overthrow the dictator Muammar Gaddafi. And it seems that the United States or the president see, it says here, the Vietnam era law requires the president to seek approval from Congress after 60 days of military engagement. The law was passed in 1973 after the United States fought the Korean and Vietnam War without actual declarations of war, but it's always been controversial. President Nixon actually vetoed the law, but Congress overrode him. According to 2004 Congressional Research Survey, since the enactment of the War Powers Resolution has taken the position that is an unconstitutional infringement of the president's authority as commander-in-chief. President Obama, defending the legitimacy of the Libyan operation, hasn't actually made that argument. On Wednesday, he submitted a report to Congress arguing that his administration isn't in violation of the act at all, despite the fact that the 60-day deadline for congressional approval of Libya operations came and went in May. White House spokesman Joy Carney has argued that the United States' constrained and limited operations in Libya do not amount to hostilities because the United States doesn't have or intend to place soldiers on the ground and has not sustained the casualties typical of such hostilities, right? So you need after 60 days, according to the War Powers Resolution, if you've committed troops to hostilities, you need a congressional authorization or it's illegal. And then obviously you can see it seems like the Obama administration flouted the War Powers Resolution in 2011, and Congress kind of complained, but nothing really came about from it, right? So I'll include that link in the description, right? The War Powers Resolution seems to be a statute that has some promise. And it seems to be a statute that also has that kind of exacerbates tension between the congressional branch and the executive branch whenever it's brought up initially, but it nonetheless doesn't have a lot of bite to it because Congress has this collective action problem. There's 538 members of Congress. Maybe it seems politically inopportune to go against the president of the same party that you have. Or maybe, the country really doesn't like people that are going against the president on issues related to foreign policy or national security or war conduction overseas. All that, I don't know what the political incentives are, but the War Powers resolution is hasn't really been vigorously enforced by Congress, and presidents have historically trampled on it. In fact, the authorization to use military force that subsequent administrations have cited as like part of the domestic legal basis by which they are engaged in operations overseas has been claimed by the Bush administration lawyers, Jay Bybee, which I didn't get a chance to talk about in this video, as sort of being, oh yeah, it was important to get that authorization, but it wasn't legally required. Like, it's well within the commander-in-chief's powers to sort of respond to the September 11th terrorist attacks, which is an interesting position to take, right? It's a very expansive view of the president's powers in times of war, right? The president's emergency powers in times of war, I should also say. Which is interesting too. I guess the last thing I'll mention is that we could also conceivably talk about the president's, assertion of executive powers in times of war that we've talked about in previous instances, especially in the Bush administration, where it was kind of extreme assertions of executive power that I will say have since kind of been repudiated or discredited. So here's a memorandum that we can see in the Office of Legal Counsel in the Bush administration Justice Department, where they claim that a statute passed by Congress barring, mistreatment of detainees or the torture of detainees, or was violative of the Constitution because it stepped on the president's commander-in-chief powers. It argued that the president had the ability, was authorized to, engage. We talked about all sorts of practices in the Bush administration, including interrogation, the rendition and detention program, enhanced interrogation techniques. Essentially, this whole memo argues that POTUS is authorized to do these things and is free from legislative interference, right? Because they are within the realm and discretion of the executive. Okay, finally, having said all that, I'm going to begin writing my essay. I'm going to try to keep it as short as possible. So the thesis statement that I'm going to write is: a strong executive is important for the long-term viability of a Republican form of government. In some instances, because it can lead a strong executive is important for the long-term viability of a Republican form of government to protect against national security threats and to enact policy and to execute policy necessary policy effectively, but a strong executive unconstrained will lead to tyranny. So it's a very nuanced argument. I don't really like this like strong or weak executive, right? Because what do you mean? And you can mean it in so many different contexts, but a strong executive is important for long-term viability. So I put that. A strong executive is important for the long-term viability of a Republican form of government to protect against national security threats and to execute necessary policy effectively, but a strong executive unconstrained will lead to tyranny. So I think this is a very effective thesis statement. And then in the next video, I'm going to show you how I integrate evidence.